Ask of this. It's the Wayne County Superior Court number 2, cause number 89D02-1209-MF-000343, U.S. National Bank Association, comma, lots of blank space, plaintiff, comma, versus Rachel, RACHAELDITTY, and Capital One Bank USA, comma, defendants, period. It's transcript of evidence at hearing held on July 31st, 2014. This was before Judge Horn. I was present and taking notes. Before the Honorable Gregory A. Horn, Judge. And on his license, it's on, H-O-N, period, Gregory Alton Horn. So the appearances are plaintiff by counsel. This is important, this plaintiff by counsel, because it's going to show who the real plaintiff is in this transcript. Appearances: Tammy Lynn Ortman, and then Rachel Diddy, pro se. And I want to see if they used her middle name up here. Those strings, these are from where I did comments earlier. The court will call for hearing plaintiff's motion for provisional order requiring payment of mortgage, comma, taxes, comma, and insurance premiums in the case of U.S. Bank N.A. V.S. period Rachel Diddy and Capital One Bank, comma, N.A. semicolon, Rachel Diddy as counterclaimant versus U.S. Bank N.A. as counter-defendant, cause number 89D02. Now, as you can see up here, the N.A.s aren't included. Not like that with the comma and the NA. They do that because they're going to create two orders with this second case. And it brings in, the court would show the appearance of plaintiff U.S. Bank National Association by counsel Tammy Lynn Ortman, and defendant Rachel Diddy appears pro se. Miss Ortman. Yes, Your Honor, thank you. And there she goes into this. She's coming in under a pretense of Rachel didn't finish a deposition, or didn't do a deposition actually, and she brought in fake documents to get to this point. So this is the result of the trial, or the document trail that I've documented so far. This is a result of this and leading up to a time, which is July 31st, 2014. So we can do them together. So she says one for sanctions based on Miss Diddy's departure from the deposition previously scheduled. Would you like me to argue on or before the other, or both together? We can do them together. What is the second motion on? Motion to compel deposition, and the court set a hearing on the damages and sanctions today. Right. Well, I've already ordered her to participate in the deposition. It is to occur following this hearing. That was ordered on May 5th. It was actually ordered, I think, on May 2nd. There is a little shifting of, they think they're being slick here, because what's happened is Tammy Lynn Ortman didn't enter an appearance when she asked for the first deposition. When she first requested that deposition. And Rachel complied with the deposition. Tammy Lynn Ortman, however, did not. She was snickering, snarling. She laughed. She didn't want a note taker there. She did everything she could to provoke Rachel. It was, and she came within 6 foot of my vehicle when Rachel was sitting in my vehicle while there was a break occurring. And she had something in her hand. So I got out and she made a statement to Rachel. So, and that's on the hotel motel parking lots video as well. So she flat was having fun, being a real witch to everybody, and then coming into court and playing these games based on false documents. She came in to provoke because what happened was Rachel did a special warranty deed over to me. And when that happened, that's when Tammy Lynn Ortman entered stage left. So anyway, the judge says he's already ruled on it. And I want to get to what I think is interesting on this hearing. Your Honor, Miss Diddy, this is Ortman talking, Miss Ortman. Your Honor, Miss Diddy is a defendant in the matter because she is the borrower. She is a mortgager. And then it says, for more than 3 years now, and they have the 3 in parentheses, in the court, which is common in a mortgage foreclosure case, right? I mean, let's get down to brass tacks. And brass tacks, he uses more than once, and he uses the word practical more than once. These are key words. I'll get to that at another time. Why should I order this against her when it's 99% of the mortgage foreclosures? This happens all the time. And Miss Ortman, because of Indiana statute, says that, and then the court helps her, allows it. Yes, Your Honor, she says. The court helps her, allows it. Tell me particulars, practically, there he goes, speaking, why I should do it. Because after 3 years, again, 3 in parentheses, the bank is out for taxes for the location where Miss Diddy lives. It's out insurance premiums to protect the property that it has no benefit in. And it has no benefit. It has no beneficial interest is what they're saying there. In part, it could be argued. And the deposition was set to try and understand that Miss Diddy has been pleading. In fact, what facts she may have that are relevant to this case. The foreclosure action should take about 90 days to 120 days. The action has been pending since September 2012. Yes, it has, because they have never answered anything. They can't answer it. They know it's the truth. Well, yes, that's all true. And why I have some reservations about her counterclaims, etc. The fact is there are other contentions that she's made, right? And we have to deal with those. Ms. Ortman agreed. We'd like to deal with them by understanding what those facts are because the counterclaim isn't clear to me. In lieu of filing a motion for a more definite statement and exercising the same difficulties over and over again, we sought to depose Miss Diddy to understand what those facts are. And see, he's already ordered that she's going to go into the deposition. And now they're talking about the deposition. This is all well played out. The court, all right, Miss Ortman, before we got to that opportunity, Miss Diddy chose to terminate the deposition. We were here again today to continue the deposition to identify those facts, but that comes at a cost. It comes at a cost to my client. Another cost in addition to the loss of the principal, interest, taxes, and insurance. The court, true. Couldn't your client file for sanctions, however, as opposed to doing it under 32-30-10, period 5.8.6? And and he asked her a question. The sanctions are different, Your Honor. The sanctions apply to the failure to comply with Trial Rule 37A. So she's bringing in these different codes when, in fact, that isn't how she pled it. The court's adding this. The legislature understood that, in fact, foreclosure actions can, on occasion, take a significant amount of time and enter a protective statute for the benefit of the lender. Yeah, especially when they assign you the wrong loan that's on another property. So the court asked her, let me ask you this. Your firm does this routinely, regularly, a major part of your practice, I assume? And Miss Ortman, no, Your Honor, it's not. Foreclosure counselor is listed as Fouty and Fouty. I have been brought in to deal, the court, I'm sorry, Miss Ortman, Fouty is identified as the court, right, foreclosure counselor. That's not my firm. I've been brought in separately to address this particular matter. What matter would that be, Tammy Lynn Ortman? The court, okay, Fouty and Fouty does this as a regular course of their practice. They're before me all the time. Yes, Your Honor. I wonder how many times they'd file something pursuant to this statute. Miss Ortman, I'm sorry, Your Honor, I do not know the answer to that question. My guess is, and the court says, my guess is not very many. Not very many. Would you agree with that? And Ms. Wortman, I would, Your Honor. The court, all right. I'm not trying to be difficult. I'm trying to be as practical as I can be. I tend to be a pretty practical judge. And while I understand the right, it's clearly set out in statute. I just wonder how practically, we are being. I'm wondering whether it's not in retaliation as opposed to being done in the regular course. And then Miss Wortman goes into her little thing. Permits, okay, so Your Honor, if we could make some progress in this case, then what the statute permits is in fact not a sanction. It isn't retaliation. It is in fact compensation for direct and immediate costs that U.S. Bank has continued to carry. In fact, the tax payment is due just 90 days from now, and again, it will incur the loss. These losses are not something that U.S. Bank contracted for. It has them, and then U.S. Bank, go to the bank that sold you the loan. And quite frankly, the court, Miss Diddy, why you haven't made a payment? Questioning, and I don't know exactly what to do. I didn't. Okay, so Rachel freaked out, but she did good. She said it was retaliation as well. But I want to get down to, because it didn't last very long. She goes into line, and why did you write down my driver's license number? This was before the break. So that clearly shows that there are some things that happened during that deposition that Miss Wortman is not totally being honest with them. I didn't say until page. The court, Miss Diddy, let me stop you a moment. You need to be careful, very careful about what you say. We take very serious, okay, especially in court, everything that's said is recorded. Okay, so when you accuse someone of not telling the truth, you better be specific and you better be exact about what you say. I don't take it lightly when you accuse a lawyer of not telling the truth. Well, I'm accusing you, Judge Horn, of being dishonest. How do you like that? Look here. How specific can you get? I'm not sure. Page 46, all of page 46 basically, it talks about my ID on the very bottom line, 24A, and why did you write down my driver's license number? And he goes into that she needs to be specific because everything is recorded, and he takes it very seriously about a lawyer. You accuse a lawyer of not telling the truth. Okay, well, Miss Wortman had just stated that I didn't mention anything about the driver's license besides the photocopying of it. I asked on page 46, 24A, and why did you write down my driver's license number? Before that, Mrs. Wortman states, certify the question. Her answer to that question that I asked, page 47, line 1, it says, to confirm that you were who you say you are. Page 47, I said, okay. Then I said, line number 3, I would like to take a break. So, so she's basically letting her know that they talked about the driver's license before the break. The break was caused by the fact that this chick took Rachel's state-issued ID and was copying it and was making that she makes statements about it in the deposition that she's going to copy it and she'll do whatever she wants. And that U.S. Bank, U.S. had already paid them. They won't allow you to. I went to pay property taxes on this property. When U.S. Bank has already paid them, they won't allow you to. So this is the judge's can't offer to Rachel going down there and them saying U.S. Bank already paid them. So the court said, so if I order you to pay the taxes that U.S. Bank has been required to pay, and you could pay that when. So this judge, later on though, this very day, and you'll see, I'll talk about it, he makes an order up. There's an order made up about this, and it's not what he says. It doesn't go into anything. It gets sent straight to this chick that pulled all these fake mortgages in. So here we go. That's it, Your Honor. Miss Wortman, anything further? Does Your Honor want an order for the clerk to accept the funds? Yes, please. All right. I'm obviously going to take this under advisement, look at everything, and then we'll sign orders. But I've already ordered that the deposition is to take place now. Yes, Your Honor. And this is the day that I went over and found that got the certified copy and went to the prosecuting attorney's office to try to speak to someone about this judge allowing fake court documents, because Rachel had the documents right there, and it's in her counter. It's on file. It's on her and I'll show this, what led up to this, which I already showed because I'm taping this to add to that. Miss Diddy, I'm being as frank with you as I possibly can. You've been filed a ton of paperwork, but it doesn't make much sense, okay, to me, and I'm assuming to Miss Ortman. We're trying to come up with a legal theory as to what you're saying, and that's what your deposition, at least part of your deposition, is going to be about. So you need to be as frank as possible, all right? It's time we conclude this case. I'm going to issue an order based upon today's hearing. This can't go on, and I'm going to issue an order based upon today's hearing. It can go on when it's a redocket, can't it? And it's the same case from 2006, it can just go on forever in there, right? But it can't go on here? Nobody wants to go on in this with you guys. This is fraud. This is fraud upon the court. This is an embarrassment. And we'll go from there. But I would encourage you to talk to Miss Ortman. Try to see if we can get the case concluded. Okay, all right. I mean, you have to understand. And then he goes into what she's done wrong. Mr. Judge, do you understand that she told you clearly it is not her fault if they did not assign the right loan to that house? She should not be expected to fund 3 separate properties in any way, shape, or form ever. It's that simple, and you know it. And then he's ordering her. Now remember when I said the plaintiff by counsel? Going to have your deposition taken, okay? All right, yes. And then you'll give me an additional order, follow-up for the clerk. And then, Miss Ortman, yes, Your Honor, I'll have it mailed out tomorrow. All right, great, thank you. It was that day, and it was an order that the plaintiff, the counsel for the plaintiff, Miss Ortman, and the plaintiff is the court. He said at the beginning he was going to have plaintiff by counsel comes, and then he said that he would to have her client get the order, and then here she comes, and he's saying that he needs, and then you'll give me an additional order follow up for the clerk. Yes, Your Honor, I'll have it mailed out tomorrow. All right, great, thank you. No, Your Honor. All right, court's adjourned. Thank you. And that is all the evidence recorded in this cause. So this hearing is being treated as a cause. And this shows where Lisa M. Rourke, the reporter of Superior Court Number 2, that she did this. And that was a good job on this one. On another one, it's a little different, but let's see if they've got this fake mortgage in here. That's the actual deposition. Veritext. And this is something interesting as well. I won't go into all that because I just as soon show the whole thing at one time. And I think that I'll insert that somewhere. But they have at the beginning RACHAEL, and then they have here RACHELLE. They can call it an original. It's not. It's from Veritext. It's a copy of an original, but everything's authenticated once they put it in this sort of format. And then see how the case is split up here as a counter complainant, where it wasn't before at the heading. Then they got the deposition of Rachel Diddy, RACHAEL. They spell it another way too. It's got a job number. That's from Veritext. It's got appearances. Oh, For the defendants, no appearance. Notice that. For the defendants, no appearance. The good job, court reporter. Direct examination questions by Ortman. Let's see if this warranty deed's in here. I can cut this out if it's not. Oh, there's the guy's name who did this report. James P. Connor. No appearance, huh? I am disinterested. And I have information on everybody that has their names on things, be that the real person or someone else. So, errata sheet, which Tammy Lynn Ortman failed to give. Now, the witness's name is Rachel Ditty, Rachel Ditty. And remember the Rachelle and the Rachael previously. This is all done for a reason, because the order is going to be a finely crafted instrument. They know exactly what they're doing. Then, of course, here's this name. Now, she did complete this, and this is turned in too. She completed. Of course, the judge kept her from putting anything in with his actions and his mannerism and the way that he acted. He knew, he knows, and he boldly didn't care. He was just doing it. He didn't care that anybody knew any of us. Who is he to care about us? I'm someone who voted for this jerk. And he's up here doing this to someone who clearly, if he's going by the law, then he's going to know it's a fake mortgage. Well, he knows. He knew. Doesn't understand what. I'm going to put it out here so that people can see it, and let's do a poll on who understands it and who doesn't. Is he incompetent? There's a Rachel again. Then the case name, it has a name of its own, reference number. Then this witness deposition. We didn't get this. We had to ask, I had to find out who did it, who this guy was, who did it, contact them, and then that's when they said, do you want both of them? Sincerely, Production Department, C.C. Tammy L. Ortman, Esquire. Comes counsel for plaintiff, U.S. Bank, comma, National Association, and then in parentheses, U.S. Bank, comma, Tammy Lynn Ortman. Affiant states affiant is at least 18 years of age and of sound mind, and all matters stated herein are based upon personal knowledge. Affiant is an attorney licensed to practice in good standing. Director with the law firm Lewis and Capps. Affiant is retained to represent and defend U.S. Bank throughout this litigation. Has done so continuously since February 2014. Nope, they did so since she did so. She put an appearance March of 2014. That's when she officially put in an appearance. The day before that, she put in a notice of deposition. Underlying mortgage notes, and I'm going to check on this to make sure, but yeah, I'm pretty sure. Underlying. Affiant has billed at a reduced negotiated rate for a time cost incurred for her representative in this manner. This is Exhibit B. There she goes. That's what she's going to charge to Rachel, because she's representing the interest of those grandchildren. And under that special warranty deed that Rachel filled out, I find it quite interesting. So here's an instance of what I talked about earlier. See this? Bad address. They don't want people to know this. This is when the postmaster stopped the mail at her house. And something, right when this was happening, it wasn't deliverable. And this is when a former owner of the house, the one that I said Judge Horn used to represent, Pamela White, was mailed this during that time, as well as a Paul Bunyan. I'll show that later. Pretty interesting stuff going on here. So this is a chronological case summary of that case. So it goes on. And this is a good chance to probably defendant's answers to request. I want to show everybody something here. This is U.S. Bank versus Rachel Diddy. The most standout things that I think. On 7/29/2013, this is this Andrew John Thompson. He files an amended appearance because back when he first filed it, he had not filed the proper appearance form. It had the wrong name and the wrong address for Rachel. Then he files an amended appearance on this date. This is after settlement conferences with the law firms and with insurance companies, and Andrew John Thompson was not hired for that. He was motion to stay for extension of time. This is when we found out about the fraud. One of the insurance agents wrote me and said that they were representing the lender's claims, already tendered claims. So we found out that he was involved in that, and he was fired. And he said he told Rachel he was going to have to quit based on moral differences. There wasn't any moral differences going on. I caught them. I caught them all collecting insurance behind the scenes on this fraud and continuing it. And they're still continuing it to this day. Nothing's been done to stop it. The government and all of the agencies, the FBI, Secret Service, Department of Treasury, IRS, the most helpful, and this is pitiful to say, has been the IRS. They're the ones that have told me what's going on. Several of the criminal investigators I have spoken with, too, that I know by name, that have told me exactly what's going on here. And nothing is being done about it. Right underneath our noses, this is going on. Right underneath. And so if somebody doesn't want to spend the rest of their life in court with these pieces of crap, then you know what? All you can do is get it down on paper, I guess, at this point, memorialize it, and it is in this case, and the truth will come out in the end. And that's the main thing. The truth comes out about what's occurring here. So the court, we sent in about what had happened, what this Andrew had done, and what he was running behind the scenes. And the court, having examined and considered defendant Rachel Diddy's motion to stay for extension of time, now finds the same should be denied. It is therefore ordered the defendants Rachel Diddy, notice the spelling here, and notice this spelling, motion to stay and for extension of time be and hereby is denied as to the stay, and the court finds there is nothing pending as to the extension of time. So the motion to stay is denied. Under this name. And as to the extension of time, the court finds there is nothing as to the extension of time. So the name that's left is R-A-C-H-E-L-L-E in this instance. So on 11/15, Andrew Thompson files motion for leave to withdraw appearance, order submitted. However, and I must show this. Carol Isaacs, that's what I wrote. Enough now. When you folks going to take action from clear over in London and to Germany and Colorado? Hold on. Let me get this, well, anyway, I go down and said, I called the title insurers and mortgage attorney on an ex parte meeting that paid the lender, and then they come in behind the scenes on an already tried case and funnel it behind the scenes. If it's a mistake, and it's not a mistake, you see. So the order on motion, Andrew Thompson filed this with this judge. He knew what was going on. The judge did the day before, because that's what this motion was. This is for an extension of time on this. She filed this to have time for an attorney because she was firing Andrew J. Thompson due to the letter he wrote, and we showed the letter that was written back to him beforehand. And so then the judge, Andrew Thompson, attorney, files motion for leave to withdraw appearance on 11/15. It's filed 11/14, and on 11/15, order on motion for leave to withdraw appearance, see order. It is ordered that the appearance of Thompson Law Office LLC by and through Andrew J. Thompson is hereby withdrawn. Well, this Thompson Law Office, and I'm going back up because I want to, this is for not just, everybody's benefit. This goes into an actual complaint. So I want to go back up to where we hired him. We actually met with him in March of 2013, and we're paying him. And but he didn't put his appearance in until Andrew J. Thompson, attorney, files appearance for defendant Rachel Diddy. And see the spelling of the name? That's the name that they're going under this former criminal case under, a criminal citation. They're going under that name. So I'll go back down. And correspondence received from Carol on February 18th about this judge, about the warranty deed, special warranty deed. So this is about that. And of course, he's telling everybody in this order, I'll read it later, he's telling everybody to don't bring her in. She has to bring herself in. But then here comes this attorney, Tammy Ortman, and it files appearance for U.S. plaintiff. And she doesn't mention Lewis and Capps. When they withdraw her, it'll withdraw the law firm, but not her. So she's sitting on the back of the case, basically on the IRS side. So on 3-5, she files an appearance, but 3-4 is when she did the deposition, and it's not entered in here. They did that for a reason. And then on 4-8, and then this is when we served them, I don't know, 700 pages or so of stuff. Senate registered mail. And this is what they did. Rachel Diddy responses to defendant's first request for admissions to Rachel Diddy. Rachel Diddy's response to first request for production of documents to Rachel Diddy. They know good and well because in the orders they name it properly, but they're doing the actual heading of the case, and the clerk is entering it this way. And according to my, under Rule 77, they're not supposed to be entering it this way, but they got Rachel suing herself right here. And then coming in under this deposition stating that nobody's putting an appearance for Rachel because they're going to make Tammy L. Ortman, Tammy L. Ortman's going to make Rachel pay her fees because she is representing an interest on this other shadow docket that's running within here. And so we'll go down to there's the hearing held right away, and then right away on 8-1, The judge said he'd take it under advisement, but right away, since he ordered her to. Entry for hearing held on July 31st. See entry. And I'll show that later. It is ordered that the defendant, Rachel Diddy, notice the spelling, shall pay to the clerk of Wayne County on or before October 31st the sum of $1,115 as sanctions pursuant to Trial Rule 37. The clerk shall promptly forward payments made to U.S. Bank care of Tammy L. Orton. That's Ortman, and they know it. They know it. It's in the order, spelled both ways in a one-page order. 1 American Square, or her then current address. So this was code. This order was key to bringing me to yet another shadow docket that I will show later. So here's the provisional order requiring payment of real estate taxes. Now this is to see order. It is ordered that the defendant, Rachel Diddy, again the spelling, shall pay to the clerk of Wayne County the sum of $380 as payment towards real estate taxes. Clerk shall promptly forward payments to U.S. Bank National Association care of Tammy L. Orton, which is the wrong spelling, or his then current address. And that's not what he said the day before. The day before he said, would you be willing to pay it if the court held it? The court did not hold it. He already told her to enter that backup order, and he is a client, it appears. I know for sure that he's got a financial, I can prove it. He's got an interest in this. It's past a mere little bit. This is the lady who owned this house he represented. And it appears that her identity is not being looked at here. I don't know who she is. For all I know, he's using her identity. The judge is. I'll know more soon. I can look over things. So anyway, we go in for this partial summary judgment. And this is where they tried to throw her in jail. We paid her. She showed up to court on